not going, you will not be reported because of the way that the web is set up. Your images and names and stuff don't appear. All right, so let's go ahead and get started. So let's define what a trust is before we talk about who this trustee and who this manager is of this trust. And at the outset, I wanted to mention that there really is no restriction on who can serve as a trustee. Any adult over 18 that's of sound mind essentially can serve as a trustee. So sometimes people are thinking, well, geez, it's got to be a bank or a professional or someone who's done it before, but really there isn't. And I know a lot of you on the call today, and a lot of our clients really select family members to serve as trustees. So I wanted to make sure I mentioned that up front, so we're all thinking of who the possible options are when you're selecting a trustee in your own estate plan. So what is a trust? I think that's a great place to start. And a trust is defined as defined in the slide, a fiduciary relationship with respect to property, subjecting the person by whom the title to the property is held to equitable duties to deal with the property for the benefit of another person, which arises as a result of a manifestation of an intention to create it. So what the heck does that mean? We're going to dissect that because obviously the legal definition is a little wordy and hefty, but we can break it down for you much more simply than that. Essentially, a trust is created when one person transfers property to another person with instructions that the property be used for the benefit of someone else. That's essentially all that it is. So anytime you're wanting to transfer assets to someone but not put them in direct control of it, you are establishing a trust. So that happens a lot when kids are really young and you're saying, okay, in my estate plan, what if I pass away before a certain age? I may not want to put it directly in their control because they're too young, or maybe they're not great with money, or maybe you're trying to protect what you leave them from divorcing spouses or creditors. So putting them in direct control doesn't make any sense. So anytime you're talking about somebody else holding funds or assets for the benefit of someone, for another person, you're talking about a trust. So what are the ingredients that you need to make a trust? First, you need the trust maker, some person that is setting up the trust, that's saying, hey, I'm the one that wants this arrangement to exist. Then you need assets, you need property, something that's going into the trust, something that's going to be subject to this agreement, which is in most cases an anticipated future inheritance, like what's left of your assets after you've passed away. The trustee is the person you're entrusting these assets to, you're giving them to this other person. And then the beneficiary, this is who the assets will be held for. And oftentimes, like I said, it's the children, the ultimate beneficiaries, or whoever you selected as your beneficiaries of your estate plan. We're going to go through how the role of the trustee evolves, because as you can imagine, that will change, because a lot of times people set up trusts that are revocable trusts, and they are in fact their own trustee. And so that's very going to look and feel very different in terms of what the role of the trustee is if you're managing assets for yourself, versus if now the person that set up the trust has passed away and now the trustee is somewhat different, managing assets for those beneficiaries. It's going to be a completely different scenario. And in all cases, the number one rule for trustees is that you're adhering to the terms of the trust. So unless the trust somehow violates public policy, or there are a handful of rules that trusts are really not supposed to deviate from under Massachusetts default law, it's pretty much the trust document that is controlling your every action. So as a trustee, your first step is always to understand the terms of that document. Significantly less stressful when it's your trust and it's revocable and you're the trustee, because you always have the ability to make changes to that trust. So you will not find trustees of revocable trusts, if they're the person that set up the trust, pouring through the rules every day, making sure they're adhering to the rules. You will find that, though, if, say, that trust maker becomes incapacitated or once they've passed away, where they're really adhering to that. And I don't want to say too much more, because Shawnee's going to dive into what is the role of the trustee while your trust maker is alive, and then if that person is alive but has become incapacitated.
Yes. So while the trust maker is alive and well, this really applies for a revocable trust. If you have an irrevocable trust, it's going to be a little bit different. But your standard revocable trust, the trust maker is the trustee. Generally, your trust maker is also going to be the beneficiary of the trust during their life. So the trust maker is in control of the assets. And in your standard revocable trust that you might set up simply to sort of avoid probate, the trust maker, while he's alive, he or she is alive and well, they can make distributions to themselves for anything they want, just like you normally would if the assets were in your own name. The sole purpose of the revocable trust is really to kind of avoid probate, make things seamless. Now, if you had an irrevocable trust, this would be different. If you had it could be that in an irrevocable trust, it just depends on what the reason for the trust is. The trust maker might not necessarily be the trustee in an irrevocable trust, so that doesn't necessarily apply here. Okay, when the trust maker is alive and not well, this is still talking about revocable trusts. What you need to do is go to the trust language to determine incapacity. How do you determine when the trust maker is incapacitated? And by incapacitated, we really mean that the trust maker, the trustee, is really unable to effectively manage their property or financial affairs. And the trust document itself is going to outline who and how you make that determination of incapacity. And the two basic ways that that is generally most commonly happened is by either a panel of people or by your physician. If there's a panel, often we'll call that a disability panel. That might be the people that the trustee, trust maker has named in their healthcare proxy to make decisions for them. But it could be other people. It's at the trust maker's discretion who they pick to make those determinations for them. It could be a spouse, it could be kids, whoever they want, and they would get together and make the determination that the trustee was disabled and unable to continue managing the trust assets.
And can I just interrupt for 1 second and say that is a very common area of trusts that we review and ultimately change with the trust maker. Because we find often that people are not remembering what the mechanism is for removing them as trustee inside their trust. And that's a very, very important thing for you to have top of mind. And how does that work in your trust? Who's going to pull my control away from me when it needs to happen? Because the capacity is not a flip the switch occurrence. It's not like one day, you're paying all your bills and the next day you can't touch a checkbook. Doesn't work that way. So it is important that you understand who the people are if it is a panel, or if you're relying on physicians. Sometimes it'll say 2 physicians, and that's pretty tricky to find nowadays, where you might get a PCP that knows you. But so that's definitely an area to focus on if you're looking at reviewing your plan.
Yeah, I totally agree. And then with the physicians, it might say 1 physician, 2 physicians. It depends on what the document says. Sometimes it might require more than 1 physician if there's conflicting opinions. So you just have to really read the trust document to determine how that process happens. And like Denise says, it's most of the time it's more of a slow progression that somebody sort of starts to lose incapacity. And obviously it's going to be exceptions to that, like if there was an accident or something drastic. But most of the time it's a slow process. So sometimes it can be hard to sort of pinpoint when that really happens. But just having, a group of people that you trust, if you're doing the panel, that you trust to kind of make those decisions for you when appropriate. So you have your panel or you have your physician, whichever option your trust says, they've determined that, the trustee can no longer continue and they're removed as trustee. The next step is to go to your document and look at the trustee succession language to determine who is going to serve as trustee now that the original trustee cannot serve. And then, you'll have to have that person accept their appointment as the successor trustee and take over management of the trust. Once the successor trustee takes over management of the trust, some of the next steps that you're going to want to take for the trust maker is to locate their estate planning documents, their living will that's going to sort of outline what their wishes are for any end of life decision making or care, their power of attorney that nominates somebody to handle their financial affairs, because not all of their assets might be contained in this revocable trust. They could have other assets outside of the trust, and that durable power of attorney agent might be the same person as the successor trustee, but it might not be. So if it's somebody else, the successor trustee and the power of attorney agent, as well as the healthcare proxy, will have to all work together, if they're different people, to figure out what the needs of the trust maker are going to be. So locating those documents is very important. So you know who, with the durable power of attorney, who's the person that has control over the trust maker's financial assets. With the healthcare proxy, who's the person nominated to make medical decisions for the trust maker while he's determined to be incapacitated. You're also,
sorry, I was just going to give an example because I think it's, until you see this play out like we have, Shani, sometimes I think it's hard to visualize what that kind of feel like. If a lot of times people will pick the same person to be the successor trustee in the revocable trust, and that person's also the power of attorney and healthcare proxy, and then there is some kind of seamlessness there, but sometimes it's not, and that's intentional. Someone's really good at healthcare decisions, but somebody's better at managing money, and so these roles are different. So you could say you've got a cognitive issue or there's a disability and you're looking to be in the facility, you could theoretically have your healthcare proxy making the decision about which facility you're going to enter because it provides the best healthcare and most appropriate healthcare for you. Your power of attorney would be the one authorized to be able to sign a contract on your behalf to enter this facility. And then the trustee, who's got access to your funds inside your trust, would be the one paying for it. Just to kind of give you a sense of how that could work.
Yeah, that's true. And then it's common to have separate, different people sometimes. Like I notice when families have multiple kids, they don't want to like leave a kid out. Like they don't want Joey to feel like, they didn't trust him. So they sometimes will name one kid for each role for that reason. Or sometimes they, you don't want to all of these things are a lot of work. So another reason to name more than multiple kids in a role is that you want to sort of spread out the responsibility so that there's like one kid isn't like doing everything. So that can be quite common that, like you said, you're working together with other people. But figuring out who those people are, so that way you're all going to have to work together to take care of the trust maker's needs while they're incapacitated, whether it's temporary or a permanent incapacity. And then figuring out what other assets they have in the trust and outside of the trust to determine, proper management of their affairs. So the next thing you want to do is to review the trust terms for how the trust should be managed while the trust maker is disabled. It will basically say what distributions you're allowed to make and to who. So it might say that it's just for the sole benefit of the trust maker, but sometimes it'll also name other beneficiaries that the trustee is allowed to make distributions to while the trust maker is alive. That could be minor children of the trust maker. It could be grandchildren. It could be, for maybe your grandchildren's education. It could be for lots of different things. It just depends on what the trust says. Generally, it's still going to be for the primary benefit of the trust maker while they're alive, but You might be able to make discretionary distributions to other people. So that's very important that you read your trust thoroughly during this time to figure out what you're allowed to do with the assets.
Yeah, that's a super important point, because sometimes we'll get, people are just really elderly and now they're handing over, they're resigning as trustee to let their child or whoever they've named as successor trustee take over. And they're also knowing that, hey, if I have over $1 million in Massachusetts, I'm going to get hit with an estate tax. So they're making these $15,000 a year gifts. And now son says, hey, mom did that every year, I'll write the checks from the trust. Well, if the trust doesn't authorize, when she was trustee, she could do whatever she wanted with her money, because remember I said earlier, if it's a revocable trust, she's got the right to change it and amend it, so she can do what she wants. When son takes over as trustee, to continue to use money from the trust other than for mom is not appropriate unless the trust authorizes that. And always remember, because you always have to remember, as trustee, your guiding principle is you always have to be acting in the best interest of the beneficiary. So you have to understand that if mom is the only beneficiary, gifting her money to somebody else is asking for a lawsuit after mom dies for the people that would have gotten that money had you not gifted it. So even though there's been this pattern of gifting, it's really important to drill down when you take over as successor trustee as to who you can make distributions to.
Yes, I agree. And also, to determine how much assets are in the trust and outside the trust, to like figure out if the trust maker has like some kind of incapacity that's going to require a lot of expensive care.
Right.
Can they afford to continue making discretionary distributions to other people, given whatever their current medical needs are? Because the trust is still going to be for the primary benefit of your trust maker. So you have to kind of factor all of that in, what's in the trust maker's best interest long term. And then, your healthcare documents, your healthcare proxy, your living will, you're going to want to get together with the healthcare proxy agent, if that's you or somebody else, and ensure that the trust maker's medical needs are being taken care of. Do they need to go to a nursing home, assisted living? Do they need home care? All this kind of stuff. Do they need you? Are they going to need money from the trust to pay for this medical care, given their current incapacity? So making sure that you're working hands-on with whoever that healthcare proxy person is and the family members to ensure that the proper funds are available to pay for whatever is needed for the trust maker's care. And that goes hand in hand with assets, determining what you have. If you're a new trustee, you might not be aware of everything that's in the trust, whether it's real estate or financial assets. So really getting a grasp of what assets that you're responsible for managing. If it's investments, working with a financial advisor to ensure proper management of the investments that you have, where appropriate. Okay. And then once you've determined what assets are in the trust, you're going to need to figure out like what are your regular, bills and expenses that you're going to have. If you have real estate, like the trust maker's primary residence is held by the trust, which is quite common, you're going to have to pay all of the regular sort of like household expenses, real estate taxes, homeowners insurance, monthly bills, taxes, all this regular stuff that would normally come up, heat, electricity, all this stuff for the trust maker, you're going to have to set up, payment arrangements for and ensure that that is taken care of. If the trust maker is no longer living in the home, if it's going to be vacant, you need to make sure that you update your homeowner's insurance coverage to note that, all of these sort of little things. Then you need to make sure that you are following the wishes of the trust maker. Sometimes they might have some instructions for their wishes for end-of-life care and for the management of the trust and what their ultimate sort of desire and purpose was. Where possible, you want to be able to follow what their wishes are as much as you can. And ultimately, your job is really to just act in the best interests of the trust maker. in managing the trust, in managing other affairs. If you're responsible for them, you want to just make sure you're doing what's best for them. And then final thing is that whenever you're acting as a trustee or fiduciary in any capacity, you want to keep really good records, because you're going to be required to account to your beneficiaries, whether that's the trust maker or whoever, after he's passed away. So you want to make sure that you have excellent records of all the money that came into the trust, all of the money that you spent going out. So keeping records of all the bills that you've paid, and some sort of tracking system, so that way if you ever have to do an accounting for the trust, that you have your records there and can easily produce an accounting to your beneficiaries and show that what you've spent in and out of the trust. All the expenses, medical costs, anything like that, you're going to want to have a record of. That is probably the most important advice that I can give people, is to do excellent record keeping. And then, I always advise people to seek professional advice, especially like if you are going to be managing financial assets. Sometimes I know I have clients, even wealthy ones, that don't have a financial advisor. They like mess around and, try to do investing themselves. I always recommend to hire a financial advisor to help you manage any financial assets held by the trust. That's the safest way to ensure that you don't like kind of put a foot in the wrong spot and invest in anything maybe that you weren't supposed to, that's too risky. And also to seek the advice of an attorney. When you're stepping in as the trustee, you might not know what you're supposed to do, right? So it's okay to hire counsel to advise you as to like your role and like what you're supposed to do with the future management of the trust, and seek advice where needed to ensure that you are properly managing the trust and making all of these distributions to the correct people. Because for a lot of your instructions, you're going to have to refer to the trust, and sometimes it's not always easy for a lay person to read through the document and understand what it says. So I think it's always a good idea to hire counsel to read it for you and advise you as to what you're really supposed to do and who you can make distributions for.
Yeah, and one thing I'll say on that slide too, because I think the considering professional advice is so critical, because like you said, John, I think it's hard for people. Some of these trusts are lengthy, and you have to understand how different provisions tie into one another, and how the word notwithstanding gets used 100 times. And how many does this cancel that out? And it is kind of nice to have somebody read it professionally, and it doesn't. You don't have to have ongoing trust counsel. You could hire an attorney, someone like us, to review the trust with you, sit with you, figure out, what your role means in this trust. And then you might be fine for a couple of years, and then want to touch base again and make sure you're covering all your bases. One thing I'll point out to people, not to scare people, but whenever you're acting as a fiduciary, which a trustee holding assets for the benefit of somebody else is certainly a fiduciary relationship. The onus to prove that you've done the right thing falls on you in our legal system, which is it's a burden shift. So if you think about traditional civil litigation, somebody suing something, I say, Shawnee, I'm suing you, you did the wrong thing. I accuse her, I hire an attorney, I accuse her, it gets filed with the court. Now she's got to, prove that, oh my gosh, I'm going to say this backwards. So typically it's on me. I've filed the suit. I have to prove that she did the wrong thing, right? So it's kind of like in a criminal case when the state has to prove that this person committed the crime beyond a reasonable doubt. The standard in fiduciary litigation flips. So if I accuse Shawnee of doing the wrong thing, I have to prove she's done the wrong thing. If I accuse Shawnee of doing something improperly or doing the wrong thing, and she was a fiduciary for that person. So if I'm saying, hey, you mismanaged that person's money, and she was either power of attorney or trustee for that person, now it is on her. She has the burden of proving that she did the right thing. So that's really, really important, because if you have not kept good records and if you've not maintained, expenses and can prove that, you've had conversations with how to prioritize using the retirement account versus what's in the trust, and you haven't been thoughtful about these things, you're going to have a hard time proving that you did the right thing, which causes people to have to make bad decisions and compromise when there are fights that break out over the mismanagement of funds. And we can, I think a lot of people don't realize, estate planning attorneys, maybe not all of them, but we certainly help people that are serving as fiduciaries do a good job at it so that they can prevent those types of situations from erupting after a loved one has passed. So very important. And actually the next presentation in this series is all about being a power of attorney. I spend a lot of time talking about that in the presentation because it is really important, because you don't want to get sloppy. It's not like it was when you were just helping mom or dad, where you might have said, hey, I didn't have mom's checkbook, so I put groceries on my credit card. So next time I did have mom's checkbook, I paid for everybody's groceries. That kind of stuff does not work. In the law calls that a commingling of assets, and that is a breach of your fiduciary duty. It's a cause of action to sue you. So you really have got to keep good records and keep everything separate once you take on that fiduciary role. So thank you, Shawnee. I'm going to try to be mindful of time here, but I'm going to now move into the role of the trustee after the trust maker has passed away. So now your trust maker, the person that set up this trust that was the beneficiary while they're alive, is deceased. So automatically you're going to have this change of beneficiaries. So now you might have, and most times there are a whole new set of instructions for how the trust maker wanted the trustee to manage whatever was put into this trust for these beneficiaries. But the first order of business really, though, is settling up the affairs of the trust maker. So they might have had specific memorial instructions. They will most likely have had some sort of service or funeral, and that can be paid for from the trust assets. There will be income taxes, estate tax returns that need to be filed, and those expenses have to come off the top first. So never a great idea. There's this little proverb here. Never a great idea to rush to distributions. There's also a 1-year creditor period in Massachusetts. So creditors have a year to say, hey, whoa, this person passed away, but they owed me money. And that's regardless of whether probate is open. A revocable trust is also accessible to creditors. So definitely not a great idea to start giving, money away right off the bat. And you might, as trustee, get pressure from beneficiaries. Like, it's been a month, it's been 2 months, like, where's my check? You have got to do some of these next steps first. And I think it actually is really nice when people hire attorneys to help them through this process, because then they get that advice right out the gate. And then they know that they can tell the beneficiaries, there's certain things that need to happen first. And obviously ordering death certificates, because that will be something you will need to be able to gain access to some of these things. So one of the first things you do as trustee after someone's passed is you want to know, it kind of like if Shawnee was talking about, and knowing who these people are that you have to work with when the person's alive after they've passed, that those team members are all that much more critical, because now you might be looking to the CPA to get the past few returns to make sure that if there's any tax liability that's going to have to get paid from the trust, that you're aware of that. Maybe they didn't file returns, and maybe there's a delinquency or liens or something that you need to be aware of, because beneficiaries are going to be saying, I get 25%, that's roughly this amount. And you got to be saying, no, hold on. We've got these expenses, these liens, these debts, we've got all this to take care of. And then we'll start counting what you're actually going to receive. Knowing who your beneficiaries are, obviously very important. Again, sometimes takes some assistance. We're working with a family right now who there were multiple iterations of the trust. The trust maker made amendments over time, and they didn't flow logically at first. And now I think we've sorted it out, but it took some work on our end and their end to kind of piece together exactly who the beneficiaries were and what those distributions were going to be. When a trust maker that set up a revocable trust passes away, that trust becomes irrevocable. And under Massachusetts state law, the Massachusetts Uniform Trust Code requires that you give notice to your beneficiaries within 30 days. So once you are aware of who the beneficiaries are, you've taken over as trustee, you have to give them notice of your address, which is essentially all you have to tell them. But you do have to make them aware that they are a beneficiary of the trust, because you are in fact now holding assets for their benefit. They have to have somebody to be able to contact and ask questions. So sometimes it's a little bit of you don't love doing it because you have to give notice and you know it's going to invite questions, and then your answer for the most part is we just have to wait and see what the assets are and what's owed where, but you've got to give them that notice. So that's really important. So again, it's kind of like when you're managing a trust, if somebody's incapacitated, is you've got to know what documents they had out there. What does this plan, this estate plan of theirs consist of? Are there multiple trusts? Maybe there was a life insurance trust or irrevocable trusts, or is it just this revocable trust? And that matters to you because one, you might be named as trustee in multiple documents, so you might be taking over in different trusts. But if you're not, there might be some collaboration with those other trustees. And okay, there's this big pot of money over here and a big tax bill. Is that coming out of my trust or is it coming out of that trust? You're going to have to collaborate with these other trustees to figure out, what's getting paid from where. And then if you are the trustee and say they've done a great job, and they're going to they have everything inside their trust. So there is no probate, because remember that assets that were not transferred to the trust during the trust maker's lifetime could be subject to probate. Exceptions are retirement accounts, life insurance policies, if there's a properly named beneficiary that's alive. So if there's no probate and you're the trustee, you're going to be the one responsible for gathering all of the asset information. Because even though those retirement accounts passed outside of the trust, or the insurance policies passed to the beneficiaries outside of the trust, you still have the duty to inventory the assets, value them, and pay the estate tax if there's an estate tax due. So as the trustee in that scenario, you're really sitting at a very, you're in a critical role, because you are in charge of gathering all of that information, valuing it as of the date that person passed away. So I just mentioned this, but it's important to identify those assets that are maybe outside of the purview of your control, but still assets you need to be aware of. So probate assets that were not in the trust, that say it was a bank account in an individual's name. You could be named in the will to serve as what used to be known as executor, executrix. Now they call it personal representative. You could be wearing that hat as well. So if there are assets outside of the trust, you might have to go through a whole probate court process to move them into the trust. But there also could be somebody different named as the representative under the will. And again, then you'd be collaborating with that person. But it's important to figure out which assets are in the trust and squarely in your control, and where there might be assets outside of the trust but coming to the trust, or creating some sort of liability. And there is a note here about disclaiming, because there is, and this is more so on the shoulders of the beneficiary to decide to disclaim. And disclaiming is when you decide, oh, it's wonderful that this person made me a beneficiary of their trust and they've left me these assets. I don't want them or need them. And maybe you just decide to disclaim. So maybe I disclaim and say, I don't need this, but it would be really great for my kids to have it. And maybe that's what the trust does if I disclaim. So you might be dealing with beneficiaries that are considering that, but just have a sense of that deadline. That deadline has to be within 9 months. And I didn't mention this on the previous slides. So we can go back for a second. The estate tax return is due 9 months from the day the trust maker passed away. So oftentimes that's really your most critical deadline, because probate you can start whenever you want, and then it will have deadlines. So there's not as much of a rush to do that, although we do encourage people to do it sooner rather than later, because that can take a long time. But that deadline to pay the estate tax is 9 months from date of death. So that's usually the most pressing deadline. And then you do an inventory essentially of, what happens is when someone has passed, you're taking a snapshot as of the day they passed away. So if that was May 5th, 2021, you're going to be valuing all the assets as of that date, which means if they had securities, stocks, you're going to be finding out the value on that precise day. You're going to be looking at the bank statements to determine the value on that precise day. You're taking a snapshot as of that day because that's the date on which you are evaluating the estate tax that's due. You're also looking at money that might have been owed to the decedent before he or she passed away. So maybe there's a refund coming their way, a tax refund or a health insurance refund, money owed to that person. That will be something that they were entitled to as a date of death. It will be part of what's included. And on the flip side, you're looking for any debts that they had, any money that was owed. Maybe there was, promissory notes with individuals, or a car loan, or mortgages, or any type of outstanding debt that will reduce the gross taxable estate. So that gets factored into that snapshot of the date of death assets that you're trying to capture. You want to prevent other transactions from continuing to happen. So we always encourage people to look at the income tax returns to see what was generating income. Take a look at the bank statements to see what was automated. You might see activity where there are bills being paid automatically outside or pulled out of a checking account. Or you might see, credit card payments, credit card bills coming in. You basically want to call and cancel all of that stuff because you're trying to basically freeze all the activity on the trust so that you are in control of everything that happens from that point forward. The tax ID number for a revocable trust is the social security number of the person that set it up. But when a person passes away, when the trust maker passes, that social security number cannot be used for them, and it can't be used for their trust any longer. So one of the tasks you have on your list is to apply for a new tax ID number, which is really simple to do. You'll be, again, looking at the terms of the trust, because remember, that is your Bible when you are serving as trustee. There will be a trust accounting provision. Maybe once or twice in all these years have I seen one that doesn't speak to trust accounting. But if it doesn't, if it's silent, then you'll be looking at Massachusetts law, which tells you need to prepare an accounting. So again, you're keeping track of everything that's incoming, everything that's outgoing, which should not be distributions to the beneficiaries until much later. So really at the beginning, you're just keeping track of inventorying what was there and anything that's coming in. I couldn't encourage you more to get professional assistance, especially if there's multiple beneficiaries. Although we have had folks where they're an only child and they didn't do anything when mom passed, and now dad's passed, and now they're probating 2 estates and settling 2 trusts, and it's very hairy. So it's probably a good idea to get professional advice, regardless of the situation, because with it can cost $450. You have a consultation with an attorney to walk through what the steps are and just make sure you're doing it right. And then you may not use any services beyond that. So it could be a pretty inexpensive process. Other times, more often the cases, people are wanting to outsource some of the work that comes with being a trustee, and then we are helping. But very important to consult with somebody and understand exactly what the distributions or the instructions are within the trust. And then you want to be prepared that if a beneficiary is asking you a lot of questions, that you're not giving them too much information too early on, but then you are providing the required information in an appropriate manner throughout the settlement process. A lot of times we set up trusts jointly. A married couple sets them up together. So one spouse passes away, and now the trust is in fact irrevocable. We get that question a lot, but I always point out to people it's irrevocable, but for whatever powers you granted the surviving spouse. So for a lot of people that grant the surviving spouse maximum flexibility and control, for all intents and purposes, it's almost still a revocable trust. It's just that technically the mechanism for changing the trust is different than it was when you're both alive. But if you're the surviving spouse taking over, you might be thinking, okay, we were both trustees. He or she's passed away. I'm now the only trustee. I can still access the funds in the trust. You will still want to consult with the trust attorney at that point, just to make sure that you're not missing anything in the trust. A lot of times in Massachusetts, these trusts are specifically designed to preserve each of your estate tax exemptions. So each person in a couple can leave up to $1 million estate tax free when they pass away to their beneficiaries. So what happens is, if in the trust you were to leave everything to your surviving spouse and you didn't have any tax language in that trust, then when the second spouse passes, that $1 million exemption would get applied to their assets in the trust, and that would be it. You would have wasted the exemption of the first spouse to have passed. So for that reason, most trusts create subtrusts when one spouse has passed. So what happens is, it's really just paperwork. So you come see us, we say, okay, here's how much was in the trust. We're going to create this subtrust. We're going to hereby create this subtrust. Paperwork gets signed, and then we'll help you decide what to put into each trust. And then what happens if you've maintained maximum flexibility for each other, what will happen is, I'll say to the surviving spouse, okay, this bucket, this subtrust will be taxed when you pass away as it passes on to your beneficiaries. This one won't be. So, hey, if you've got to prioritize, use this one first before you use this one. And then that's pretty much it. So minimal work to be done, but definitely important to not neglect the fact that there might be some work when one spouse passes within the trust. Getting back to taxes a bit, because this, like I said, is really one of the deadlines that makes people have to get going on this. And when people are grieving, having to do work like this is really not all that fun. But I always point out to people, be very blessed that everything was in the trust, if it's all in the trust, because at least you have access to assets and you're not layering in the probate process, because the probate process involves a lot of waiting to even be able to access the funds. At least in the world of a trust, you're really just figuring out what the assets were and you've got immediate access to them. So now that deadline to pay the estate tax is really your biggest concern. So if you think the assets of the trust that you are now tasked with managing are going to be in excess of $1 million, you're almost always going to seek professional assistance, because I can't think of a single layperson ever that's unless they're an accountant on their own, which then I wouldn't call them a layperson. No one's filing estate tax returns on their own. It's really, they're completely different animals than income tax returns. It's not something that TurboTax is going to walk you through. So most times people are hiring professional assistance, and it's because we have certain ways we describe assets and fill out these forms, then provide them to the Massachusetts Department of Revenue in the order and manner in which they want to see everything, and then it's a pretty smooth process, but you need to income tax returns. No one ever likes filing the income tax returns for someone who's passed away, and there are more returns than there were while they were alive, and that can be a lot to just process. So imagine this, using my example before, if you've got somebody that was alive until May 4th, 2021, they will have generated income reportable to their social security number through May 4, 2021. So that's one income tax return that has to get filed. If everything was in the trust and you as trustee apply for a tax ID number after that date, all of the income in the trust will be reported to that tax ID number. So now your trust will file an income tax return as well. So there could be just two returns. If, however, there were assets outside of the trust that were in the name of the trust maker that hadn't gotten put into the trust, now there will be income reporting to the decedent, but it can't use the social security number that expired on May 4th. It's got to use a new tax ID number, which is the estate income tax ID number. So that'll get, usually it's the person trying to settle in the probate estate, which again could be you. That person is applying for a new tax ID number. That will be a third return. And then you're also looking for any returns that didn't get filed in the past. So one of the first things we always ask our trustees to get is the last 2 years of income tax returns, to one, make sure that they've been filed and they've been done, because that is your responsibility to find out if they have been or not, and then make sure everything gets taken care of. And that can be tricky if people don't have clean records, but there are ways to get that information from the businesses. Again, all something that an attorney helping you settle the trust can walk you through. So then you're going to paid the estate tax, taking care of all your income tax returns, paid funeral expenses, all of the expenses. So now you've got maybe a big pile of cash, maybe there's some real estate, maybe it's just investments, whatever's left that's now ready to go to the beneficiaries. You're now shifting into the most important part of your role as a trustee, which is really just managing the assets for those beneficiaries. So now you're looking at the terms of the trust. And this is where earlier I was saying you want to be digging through the provisions in this trust and make sure you know it backwards and forwards, because this is your Bible for managing the funds. So for families that we do a lot of plans for, they've outlined very specific instructions where you can provide for health, education, maintenance, and support. At 30 or 40, maybe their child comes on as a trustee with you, and then maybe your role ends at a certain point, or maybe it's indefinite. You really need to understand when your role starts and ends, and what guiding principle you're using for making distributions. So some people will say, you know what, be very liberal in making distributions to my beneficiaries. I'm fine with it. And others are trying to protect it for divorce and asset purposes, because they're worried about what happens in their kids' lives, and they really want them to be self-sufficient. So they're not wanting these liberal distributions out of the trust. So where you're the gatekeeper between the beneficiary and their inheritance, you really have to understand how the trust maker wanted the distributions to take place, and really what was the purpose of the trust. Sometimes these trusts are set up as special needs trusts, which are really designed for folks that are disabled and maybe receiving benefits. And now you have not just the trust rules for how to administer the trust, but you also have guidelines that the federal government puts out that you have to adhere to. And in some cases, you might be saying, whoa, this money currently doesn't kick them off their benefits, but now it does because of this rule change. And sometimes you have powers within the trust to make administrative changes to correct that. Again, all of these issues are things that getting counsel to walk you through could help you consider. And then if the trust says to make outright distributions, that does mean that you're going to basically wrap up the trust. So if after paying everything, there are no further instructions, it says, okay, once you've settled up all of my affairs and paid for all of my expenses, just go ahead and give it to the beneficiaries. Then you will do an accounting. So you'll make sure that you can report to the beneficiaries how you manage the assets while you were serving as trustee. You'll provide them with that accounting, and then you will make the distributions to the beneficiaries. So I'm skipping around on some slides because I want to leave time for questions. I think that this presentation, by the way, if anybody wants us to email it to them, we can, because it's going to go through at the end here. It goes through some of the specific duties that are outlined. It's nice to see them articulated, but a lot of them are, I think, very logical when you start to think about it, protecting the assets, providing information to the beneficiaries. So I'll leave those for you guys to go through on your own. I'm going to stop the share real quick just so that I can see the question. Okay, one question was, two people asked about sharing the slide deck, so not a problem. We will make that available, and also the presentation will be recorded, and it'll be on our YouTube channel. So another question just came in. How do we deal with checking accounts held by a person with their child also listed as an OR on the account? Does this put the assets out of the trust administrator's reach for financial use? So that's interesting, because it's the question is, what happens if you've got accounts that a child was on? This happens all the time, where people put their child on an account because it's convenient for them to write checks. They live close by. They're helping take care of mom and dad. It's the question of what was intended when they put that child on the account. So if it was just for convenience purposes, then technically it's not supposed to just fall to that child. It's supposed to be a probate asset. But realistically, what happens is that child, because they were a joint owner, they have survived mom and dad, they have access to that account. So they can either do the right thing and just a lot of times, honestly, people will do the right thing and pay for the funeral and use the money for settling. But they could also turn it over to the trust. And then it could be administered as part of the trust. But if you've got a problem with that beneficiary and they're trying to say, no, they didn't put me on for convenience purposes only, they wanted me to have the balance of that account, then you might have potential litigation issue. You can always go back to the forms that were used to add the person to the account, because a lot of the forms nowadays have a button you can, like a tick box that you can check off that I am only adding this person for convenience purposes. They're not intended to be, this isn't like a giant gift to them in the end. If you've got that, then you've got a really strong case to get that moved into the trust. But if you don't, then you might have a real legal battle as to whether that was intended to be a gift or something that should be available to settle the estate. And I've seen people do the right thing, and I've seen people do the wrong thing in those situations. Another question has come in: what are the executor's obligations to inform the beneficiaries of a trust as to asset distribution, fund management, etc.? And should beneficiaries expect a full accounting of the trust, and at what point? And if executor is not forthcoming, what steps do the beneficiaries need to take? So again, always the answer to trust questions is check the terms of the trust first, because there is a general duty to keep your beneficiaries reasonably informed, which I think sometimes beneficiaries think means that they're going to be involved in every single decision that gets made along the way. And that is absolutely not practical. In most cases, you know, if you've got 2 kids, maybe everybody can weigh in on every decision that gets made, but more often than not, there's more beneficiaries than that. And it doesn't make sense, not cost efficient, especially if you've hired an attorney to help you, to involve them all along the way. And while there is this general duty to keep your beneficiaries reasonably informed, there could be within the document, there could be provisions that say that the trust maker really didn't want to be very forthcoming with information and wanted the people settling it to be private along the way. At some point, most trustees will provide an accounting because they're looking to be released of their role and released of the liability they took on in performing their duties. So most often they will be presenting to you an accounting. You can request an accounting, again, always looking at the trust provisions about whether they're obligated to provide it. Most trusts do say you have to render an accounting. I think I see a lot of frustration with beneficiaries like midway through the process, and it really probably takes about a year on average. And it's 6 months in, they're like, I want an accounting. Well, it doesn't really make a lot of practical sense to do an accounting 6 months in, because you're still gathering assets and valuing assets, and then you're just about to file the estate tax return. You haven't really even started giving out money, and you're still capturing information at that point. So doing an accounting at that point doesn't usually make sense. But you usually are presented, before you receive a distribution from a trust, you're very often presented with what is called a beneficiary receipt. It's something we advise all of our trustees to do, and it's pretty much common practice. And it will ask you, it will tell you, sometimes it will say in there that you're waiving the right to see a more detailed accounting. So it's important you read those agreements and then decide if everything went great and you're not worried about, how many questions about the trustees' performance of their duties, you may be fine waiving the accounting. But in other cases, you might say, no, I'd really like to see how everything was. Well, show me what came in, show me what went out, show me how everything stood. And you might want more detailed information before you sign that type of agreement. Another question, and then we'll wrap up. Is there a fee that is applicable to the trustee takes for managing the trust after the deceased through distribution of funding? So trustees are entitled to reasonable compensation in Massachusetts, at least, and I'm sure that's probably true in most jurisdictions. The definition of reasonable is really just based on the facts and circumstances. So I always use the example of, you could have a $15 million trust that's got one investment account, or you could have 2 families that have 20 tenants or whatever. It's all dependent on how much work is involved in your performance of your duties. So some trustees, like banks, investment companies, will charge a fee for the percentage of assets under management. When we serve as trustee, we bill hourly for our services. And then for layperson trustees, we always just talk through if they're going to charge a fee for their services, what their skill level is. You know, some people have some accounting background or might have some relevant skill sets that warrant a slightly higher rate. If they've got no experience, maybe it's $35 to $50 an hour, and then we just have them keep track of their time, just to make it as fair as possible. Be able to justify the expensive fee, but they're certainly entitled to compensation. Yes. All right. So thank you everybody for all those
There's
questions.
just one additional question, Denise, actually.
Oh, there is. Did I miss one? Sorry.
In the chat.
Go ahead.
It says, how much time is allowed to sell major assets such as house after death of the trust maker?
So there's really, like everything in the law, there's never black and white answers. It's really what's reasonable, right? So I had a case one time where there was a disabled child living in the home, and the timeline for what was reasonable to get you live there for her entire life and never lived anywhere else. So we let that go for a full year, really, before we said, all right, now we really do need to be pushing for her to find somewhere else to live. But if that's not the case, and house is vacant and there's no market conditions or anything that is making it a bad decision to sell, then it's just a reasonable time frame. So usually that's about 6 months to a year. After a year, you really have to account to your beneficiaries for having not done that, and they can't. So if you haven't made distributions, there's a potential for interest being charged. So usually at a year, we're saying you've got to have made some decision, but it's usually not, unless it's, oh my gosh, it's winter and we don't want to pay to maintain this property through the winter. Sometimes it is pretty quick, but I would say it's about 6-7 months. What would you say, Shani?
Yeah, I think so. It does depend on the circumstances. Like you said, if the house is vacant, they're probably going to sell it right away.
Yeah.
And if it's not, and there's something else going on, like you said, the disabled kid, there could be reasons to delay. But you have to just figure out what your circumstances are.
And if it's not in the house is not in the trust, remember you've got probate, and probate you're not even appointed through the court until probably 2.5-3 months in. You can just hire a broker, sign a PNS. So those types of considerations. All right. So just to be respectful of everybody's time, I will go ahead and sign off. But just to remind you, and now I turned off my slides. Let me see. I wanted to make sure I tell you when the next presentations are. So the next one is Tuesday, August 17, also at 8:30, and that's how to service power of attorney. And then Tuesday, August 31st is our last one, and that's avoiding and simplifying probate. So if you can join us for any of those, please do. And thank you again, everybody, for your time and for joining us this morning. Take care. Bye.